BOATWRIGHT Construction.
May it please the court, my name is Larry Oldham. I'm here on behalf of Appellant and Cross Appellee BOATWRIGHT Construction. This case involves what I guess when I first looked at it, it involves what I believe was a crime, basically, I guess allowed by the Florida legislature. It essentially boils down to a party who represented himself to be a qualifying agent, or that could have been an authorized qualifying agent for BOATWRIGHT Construction in the state of Florida under existing statutes. BOATWRIGHT relied on that, actually used the gentleman as a qualifying agent, and then turned out to find out at the end of the day that because of some peculiarities in Florida law and the way that this statute that we're dealing with has been applied, that it was beaten out of about $201,000 that was rightfully due to it. The standard of review.
Explain to me whether BOATWRIGHT Construction could have under what circumstances?
Under what circumstances could, if they would have had an actual qualifying agent? I mean, as it turns out, under Florida law, they believe that they had a qualifying agent. Mr. TARR actually meets the requirements of what a secondary qualifying agent would be, except for the fact that he didn't do any supervision of this project.
So Mr. BOATWRIGHT TARR could have qualified them to do this project.
Clearly, Your Honor, he could have, and everybody believed that he did.
The only deficiency was his failure to engage in the supervision that was required in the statute.
That's correct, Your Honor. And what ended up happening here is the parties actually believed that Mr. TARR was a qualifying agent. The only way that, and BOATWRIGHT had built other restaurants for Red Lobster for this Darden restaurant group. GMRI, who was the owner here, had built a number of other restaurants for him in other states and was asked to come down to Florida to build this restaurant, or to bid on it. BOATWRIGHT did that and had actually had some dealings with Mr. TARR over the years and said, hey, coming to build down in Florida, what I need to do. Mr. TARR says, hey, I can act as your qualifying agent. I can pull your permits and allow you to do the job. BOATWRIGHT actually did that, let Mr. TARR pull the permits, did the job, performed the job.
What's the purpose of a qualifying agent? I mean,
the purpose of the qualifying agent, the purpose of the statute is to make sure that unqualified contractors aren't building projects down here in Florida.
and isn't the purpose, I mean, if you have a qualifying agent who's a licensed contractor, it means that they do work that is poor, to a degree where they can have their license taken away.
That's correct.
You want a qualified person on the job.
That's correct.
Now, your client said, we'll pay you $2,500 to draw the permit. You don't have to do anything else.
Your Honor, that's not actually what happened as far as the discussion went. That's the effect of what happened.
That's the effect. I mean,
that is the effect. BOATWRIGHT, there is no question and no evidence in the record to show that BOATWRIGHT is not a qualified contractor itself. Later on, it did become a qualified contractor here, a licensed contractor under the laws of Florida, but I recognize for purposes of this discussion that doesn't matter.
I mean, your client, as far as the record indicates, your client made a decision, whether knowingly or not knowingly, as far as the law, made a decision to not have a licensed contractor supervising the work.
No, what my client did make a decision to do is to perform a contract in Florida that it understood. It didn't understand that there was anything more that Mr. TARR needed to do. I understand what the issue is with the law, Your Honor, in that Mr. TARR didn't actually act as a qualifying agent. Now, what's important for the court to understand is that once the Florida Department of Business and Professional Regulation got involved and contacted the parties about this, Mr. TARR submitted an affidavit saying, hey, we didn't know we were doing anything wrong. We're going to do what we can to fix it. The parties actually did fix it. They entered into an agreement with GMRI where Mr. TARR agreed to basically accept the responsibilities as a qualifying agent. It said in the agreement itself that Mr. TARR intended to be a qualifying agent, so he entered into this affirmation and acknowledgement where he agreed to undertake those responsibilities. BOATWRIGHT agreed to guarantee Mr. TARR's performance under that, and Mr. TARR agreed that he knew now that the payments would be coming to him from GMRI and that he would pay those payments over to BOATWRIGHT. BOATWRIGHT continued to perform the work for purposes of the court's inquiry here in the record. We've got to assume that that this deficiency with the contract was actually cured by entering into these agreements, and that Mr. TARR then performed the duties as a qualifying agent for purposes of the statute.
Why did the money go to TARR?
That was actually, Your Honor, from GMRI's perspective. I guess when this came about, everybody looked at this and said, hey, we've got a situation here where TARR is actually, I guess GMR was worried about the enforceability of the contract itself. So it said, we've got to make the payments to TARR because TARR is now our contractor. And then TARR agreed.
In a normal situation where you have someone being a qualifying agent under the statute, are they the ones that apparently have the right to payment?
I wouldn't think that would be the case, Your Honor. I think what the parties were trying to do, and what's sort of clear from the record, is they were trying to fix what was a problem that was pointed out to them by the Florida Department of Business and Professional Regulation, and so they felt like that was the appropriate way to do it. This case really has never gotten off the ground as far as evidence in the record. The court is constrained to consider the facts that appear in the light most favorable to BOATWRIGHT as the appellant here. But I don't know. I can't even answer those questions yet, Your Honor. I mean, there have been no depositions taken. I mean, this matter started out as a motion to dismiss. Then it was a motion for judgment on the pleadings, which then was turned into a motion for summary judgment. And the trial courts below decided that it was a situation where the law was so clear that there was no reason to get to any other facts. So,
This was based on trial court's conclusion that as a matter of law, BOATWRIGHT had no right to be in these money.
period. That's what basically what the trial court decided, that under no set of circumstances could BOATWRIGHT get to this money, which is not really what Florida law says. And I believe that the trial court actually did BOATWRIGHT a favor under these circumstances. We could be here 2 years from now after spending another $30,000 or $40,000 developing the evidence in this case and presenting the facts and having a trial on the merits, and then we'd be back here with this very same issue. So what we are certainly appreciative of is the fact that the court decided it was appropriate to bring this matter before Your Honors at this point rather than on down the road.
Let me ask you about as I understand it, the ultimate complaint had 4 counts in it, right? There's a breach of contract count, a breach of fiduciary duty count, an unjust enrichment count, and a third-party beneficiary, correct?
Correct.
The breach of contract count is tell me what the terms of the contract were
Well,
that are the subject of the breach of contract.
That's an interesting question, Your Honor, because what the real contract that has been breached here is the contract between BOATWRIGHT and Mr. TARR to act as a qualifying agent. I mean, Mr. TARR has indicated that the contract is the contract between GMRI.
Okay, but you sued and alleged a breach of a contract between you and Mr. TARR.
That's
right?
correct.
What is the contract? What is the nature of the contract or the contractual obligations under that contract that you say was breached?
The nature of those contractual obligations were to serve as a qualifying agent to allow us to perform the work under the contract, to receive whatever payments came in, and to pay those over to us, less compensation to Mr. TARR for the services that he actually performed under the contract. So we're not talking about the GMRI contract, and I think what the court's got to look at is the fact that the parties sort of corrected this thing after the fact.
I'm going to get to that in a minute, but let's start with that contract.
All right.
Is it your position that knowing now what you know about Florida law, knowing now what you know about what this qualifying agent did or didn't do, is there any dispute that that in fact was an illegal contract, that you couldn't agree to the terms that are set forth in that contract legally?
I guess I could say, I mean, it would be easy to just say no, it would be easy to say to just forego that argument. I believe that this court, and I did in the reply brief, dealt with a lot of ways that courts interpret statutes. This court may decide that it doesn't have the ability to construe this statute. I think that's what happened with the trial court, is the trial court decided that it was constrained by the language of the legislature. I know that Justice Griffin, there was a Sterner versus Phillips opinion that I believe was yours that talked about sort of an unjust result under this statute. What you did discuss in that case was there was not a quantum Merowith theory that was alleged at that time, and based on the language of the statute, you noted the possibility that this issue wasn't, the issue wasn't before the court in the Sterner versus Phillips case, but I believe it's before the court now. There is a possibility under the statute to recover under a quantum Merowith theory, which we've advanced. I don't believe, if you look at the legislative intent and the purpose of the statute, I believe the courts have been wrong about the way they've interpreted that. I believe it's been a harsh result, and I understand the courts sort of feel constrained to do what they think the legislature is directing, but there's some obvious legislative intent in the history of both the notes of the legislation and in some of the court decisions that discuss the fact that what the legislature was worried about is shoddy work by unlicensed contractors and the danger to the public. This law sort of came about after Hurricane Andrew and after some of the problems there. I don't believe that this actually applies in a situation where you're dealing with sophisticated parties. I do understand that that's not, the court would have to actually apply a reasonable interpretation of the statute. The court may feel constrained to take the statute as it is, but I certainly believe it's within the province of this court to say, hey, applying this statute as it is under these facts would lead to an absurd and unreasonable result, and so we can find there was a breach of contract here.
Let me shift to the count for third-party beneficiary of a contract. Now, the contract that you allege you're the third-party beneficiary of is the contract between TARR and the owner, in which they agreed once they got paid and got a hold harmless, they would give the money to you?
That's correct.
At that stage of is there anything inherently illegal about that contract, as far as you're concerned?
I've wrestled with that issue, Your Honor, because it's the same. It comes into the same sort of idea as, hey, if it's an unenforceable contract on the one hand, and what we're really doing is allowing under a third-party beneficiary theory that BOATWRIGHT to have the same recovery that it couldn't get directly. I don't believe that it's the same thing, because I believe that the way what the parties did is corrected this.
Well, and as I understand it, there's a new promise. So
Right.
I'm really looking at the new promise.
And I think the new promise is.
Was there any? Forget your position of the contract between TARR and the owner. Was there anything illegal about that contract, where the owner said, "I'll pay you," and TARR said that they'll pay the money over to you once they get the hold harmless? Anything illegal about that contract?
There was nothing illegal about that contract.
Okay, what was the basis on which the trial court threw out the third-party beneficiary count?
I honestly don't know, Your Honor. I didn't see any reason for it to be thrown out, but I think what the trial court was trying to deal with, and what the trial court addressed in the decision and talked about the Gouverneur case and said, hey, the court has decided, or the legislative intent is that there's an unlicensed contractor cannot recover, period, under any set of circumstances. I believe that was clear error by the trial court. And again, I don't care that the trial court made that error, but I'm actually appreciative of that, because it puts the issue squarely before this court.
Let me ask you this. Could your client have sued GRMI for that $200,000?
I do not believe so.
Okay.
Again,
All right.
under.
The reason I'm asking about that $200,000 is your client could not have sued GRMI, it looks like, under the case law for that $200,000. Now, what if GRMI had told TARR, look, you're on the hook for this work by entering into this agreement. We're going to pay you an additional $20,000. Okay, so GRMI says, we're not paying BOATWRIGHT that last $200,000. We're going to pay you $20,000 for taking on these additional responsibilities. would you have a right to collect that $20,000?
I believe we do, Your Honor. I mean, I just think the law here and the way that it's been applied by these courts is terrible. I mean, at the end of the day, if you look at what the purpose of this legislation is and what this court is required to do, I mean, it's required to reach a just and right result. And there is no way, I know Mr. TARR and his counsel argue, hey, this is a situation where we just both got caught, so we get to keep the money, and that's okay. I would like to believe that under the law, if GMRI and TARR had entered into that kind of agreement, that BOATWRIGHT, who actually performed the work, would still be able to recover.
So is this cause of action really GRMI's? I mean, they say, look, TARR, we paid you this $20,000 to give BOATWRIGHT. You didn't pay it. We're suing you.
I believe GMRI could have had that cause of action. I think that BOATWRIGHT was the intended beneficiary of that agreement between TARR, BOATWRIGHT, and GMRI. So I don't think that GMRI is the one that needed to actually bring it. I think that BOATWRIGHT was clearly an intended beneficiary of that agreement. So
Could GMRI simply have said, I'm not going to pay it at all to anybody, and would TARR have any cause of action to get it from GMRI at that point?
Well, under the acknowledgement and affirmation agreement, if you look at that situation, I don't think GMRI could have said that. I think before it entered into that agreement, under the law and the way that the cases have been decided, it probably could. I mean, this law has been used to beat subcontractors who performed work out of their retainage, that when it was clearly an unjust and inequitable result. I mean, it's not the way that this law was designed to operate. So after the acknowledgement and affirmation agreement, and after the guarantee of performance, and after TARR agreeing that when he were to receive the money, he would pay it over to BOATWRIGHT, and TARR's acknowledgement that TARR had done nothing. I mean, BOATWRIGHT had done the work. So I think under those circumstances, GMRI couldn't get out of this deal. I mean, you would run into some of the in peri delicto and other analysis that are in the briefs that discuss the situation where if GMRI entered into that agreement knowing that it didn't correct the situation and then try to get out of it, I think there's authority that GMRI would have to pay that money. I'm going to use the rest of my time for rebuttal. Okay, thank you.
May it please the Court, my name is Patrick Kroll from Orlando, representing the appellee Scott TARR. The complaint in this case fails to state a cause of action and can't state a cause of action because of the legislative pronouncement in 489-128 and because of the common law of this state refusing to enforce illegal contracts.
Was your contract with the owner to receive the money after the work was done, was that a legal or an illegal contract?
That was a legal contract, Your Honor. However, it said absolutely nothing about BOATWRIGHT. That contract says nothing about BOATWRIGHT. It does not evidence any kind of an intent.
Well, there was a letter, right, that your client sent to Darden Restaurants that said, make the final payments to me. Once I receive my hold harmless agreement from Mr. BOATWRIGHT, I will endorse the final check over to BOATWRIGHT Construction.
Yes, sir.
Is that an illegal undertaking, or would that have been legal? Would your client agree with Darden Restaurants, enter into agreement which says you pay me, and when I get a hold harmless agreement, I'll pay BOATWRIGHT? Anything illegal about that?
Yes, sir, because it is doing indirectly what BOATWRIGHT could not do directly.
Okay, so Darden could have simply not paid your client, and there's nothing you could have done about it because it would have been illegal under this agreement?
My client could have sued Darden under the acknowledgement and affirmation of duties agreement because that was, as between Darden and my client, for my client to assume, in essence, it was a novation. The Department of Business and Professional Regulation came in, found out about this situation, and said, Mr. TARR, you're taking over. And Darden said, you're taking over. And so they ousted his client, and they put in my client, and they said, you're going to finish this contract, and we're going to pay you the balance. My client, as between it and Darden, could have said, okay, I took over, I've assumed these responsibilities of warranty and paying off subs and stuff like that. now pay me, because that's what our agreement says. But could not have then turned around and given the money legally to BOATWRIGHT, in my opinion, because that's then the whole purpose of the statute is thwarted. And BOATWRIGHT is getting indirectly what it can't get directly. And that was the basis of the judge's award.
And what's the whole purpose of the statute that you say would be thwarted?
Protection of the public, Your Honor.
From what?
From unlicensed, unqualified contractors doing business. Because, Your Honor, and this is an anomalous situation, the result that they advocate would be a real anomalous situation, and that is because they have conceded in their briefs and before the lower tribunal on the record that their contract with the owner, number one, was illegal because they were unlicensed, and that their contract with TARR for $2,500 rent his license to have permits pulled was also illegal. So under those two scenarios, they could not in any way, shape, or form get the money from GMRI if GMRI chose not to pay them. And now, suddenly, because the Department of Business and Professional Regulation catches them and says TARR has to take over, now their position is that they now can get that money. And that, to me, is a strange anomaly.
Well, can GMI sue your client for $200,000 less the reasonable value of his work?
No, sir. In my opinion, they cannot, because they agreed to pay my client the contract balances in the affirmation agreement. And my client undertook to take over the job, did take over the job, finished it out, and they agreed to pay my client. And my client is licensed. It was a novation. It was a complete novation. BOATWRIGHT is out, TARR is in, and we're going to finish. And the agreement even says as though TARR was the original contractor all along.
Well, could the owner have sued your client, in essence, in fraud, to say the only reason I paid you the money is because you sent me a letter saying you were going to pass it on to BOATWRIGHT, and you didn't intend to pass it on to BOATWRIGHT? So you defrauded me out of $200,000 because I never would have paid you if you weren't going to pay it on to BOATWRIGHT?
No, sir. Because fraud to me is based on a material misrepresentation of fact. And there was no material misrepresentation of fact in that letter. What there was a statement of intention.
But if it were...
How can be supported by a statement of intent?
Yes, sir. Yes, ma'am, it can. It can be supported by a statement of intention, but it doesn't necessarily, just because someone changes their mind doesn't mean that there's fraud. And that's what happened. I mean, you can look at the exhibits to this complaint. The exhibits tell all the story.
Let me just ask you a quick question. You said that the affirmation contains the undertaking by GMRI to pay TARR.
Yes, ma'am.
Where is that?
Actually, that's a good question. It really doesn't say that.
The only thing that says that your client gets the money is the letter.
The only thing in this record that's correct.
The
Yes.
only thing in this record is a letter that says, you send me the money, and I'll pay that money over to him once I get my whole harmless, which indisputably he got.
That's a big issue of contention, Your Honor. They sent a hold harmless that was not satisfactory to my client.
He didn't reject it, did he?
Yes, he did.
Not until you got involved.
No, he rejected it, and that's in the exhibits as well.
Well, for judgment on the pleading purposes, they allege they gave him the hold harmless, right? So at least at the pleading stage.
Yes, but
We
they
take
also
that
attach exhibits to their pleadings that show that the hold harmless was unacceptable. It was just very narrowly drafted and didn't cover all of the possible warranties and liabilities that he was going to have to undertake.
I haven't seen that letter. So there's a letter from your client going back to them in response to that saying this isn't good enough.
I believe so, Your Honor. That's correct.
All right, but from a legal standpoint, I guess my point is, I'm having trouble understanding why this statute really has anything to do with this transaction.
489-128? Well, there's two statutes.
The statute deals with contracts by an unlicensed contractor, and it says that they'll be unenforceable. But do you agree that if Mr. TARR had undertaken to do what he had a duty to do under the statute, that BOATWRIGHT could have handled this project legally? BOATWRIGHT could have built this project if TARR had done what the statute required him to do, couldn't they?
I believe your question's kind of mixing apples and oranges, Your Honor, because
BOATWRIGHT had entered into a contract with Mr. TARR, said, pull the permit, do all of the supervision as the statute requires. They could have built this building, could they not?
yes, but that's not the nature of the agreement between TARR and BOATWRIGHT. Okay, yes.
There's nothing inherently, essentially the problem here was what the extent of the obligations undertaken by Mr. TARR.
Correct.
What they agreed to wasn't sufficient to meet the requirements of the statute.
That's correct.
So after the fact, they entered into another agreement that essentially solved the problem, did it not?
Not,
It went back retroactively and did what the statute required.
not TARR and BOATWRIGHT. Who did that was GMRI and TARR. They said BOATWRIGHT is out, TARR is in, and it's a novation. It's a completely new agreement between TARR and GMRI.
It's also as part of the agreement that you send me the money, and as soon as I get a hold harmless from BOATWRIGHT, I'll pay the money over to BOATWRIGHT.
That was not a part of the agreement, Your Honor. That is a separate letter. It's a side letter. There's no consideration for that. There's no statement. It's just simply a separate letter that
What
was...
was the consideration from BOATWRIGHT then for the whole harmless?
Well, clearly...
They get for their promise to hold the money.
I think that clearly the intention was
If they get the money.
that they get the money. Yes, Your Honor, I agree. But what happened, and this story is told in the exhibits, what happened was that Mr. TARR realized at some point in time that he had only gotten $2,500 for closing out this contract for assuming all kinds of warranty obligations and for undertaking payments of the subcontractors and things of that nature, and decided, this is all shown in the exhibits to the complaint, and decided that he needed more money. And they argued back and forth whether he was entitled to any more money. And he said, look, I'll pay you $110,000 out of this $200,000, and I'll keep 90 because that's the reasonable value of what I'm now having to do. And they said, no, sorry. They said, you pay us 140. And the parties between themselves, Mr. TARR and Mr. BOATWRIGHT, got to a point where they were only 30 grand apart. They were only 30 grand apart. And then the lawyers got involved, and suddenly Mr. BOATWRIGHT started negotiating backwards. And then we ended up in this lawsuit.
Well, what that sounds like to me is a clear understanding between these two parties that they had a binding contract between them to share this money. And the only issue is how much each one is entitled to. And that your client would be stopped to deny the existence of this agreement.
Well, that agreement...
The only question then becomes whether, as the trial court found, that as a matter of law, they could not make such an agreement.
Correct. I agree. And they can't. Because then Mr. BOATWRIGHT is doing indirectly what he couldn't do directly.
But by then, they had already retroactively solved the problem of the of the lack of the license, because your client had undertaken to do that which was necessary to be responsible for the entire transaction, for the entire project.
By then I'm sorry, Your Honor, could you?
I said by that point in time, your client had already undertaken to do that which he was required to do. They retroactively solved the problem of the defect in the relationship, which was the extent of the responsibilities that your client would undertake.
That's between my client and the owner, that's correct. But BOATWRIGHT was out. BOATWRIGHT was off that job, and there was no more contract with BOATWRIGHT between BOATWRIGHT and the owner. Because the Department of Business and Professional Regulations said, you can't do this.
But after the problem was cured, any payment that then might go to BOATWRIGHT doesn't thwart the purpose of the statute, correct?
It absolutely does. Because BOATWRIGHT is then being rewarded for coming down here and entering into a contract and engaging in general contracting in this state without a license. And then, if you allow that, every unlicensed contractor is going to come to Florida and say, we can do this same thing.
No, because the owner can say, we're not going to pay you, and you're out of luck. But that's not what the owner did in this case. Isn't the statute designed to protect the customers who get the construction work done?
It is, on one tier, it's designed to protect the customers, but on the more important tier, it's designed to protect the public. For example, the Hyatt Regency case in Kansas City. You know, there was a dispute there about the subcontractor changed how they hung all of the atrium walkways, that famous case, and 114 people died. Imagine if the unlicensed contractor in this case, while he's constructing this Red Lobster, decides that he can change the truss design without the engineer's approval. Or imagine if he decides that, contrary to what is the practice in this state and the code in this state, imagine if he decides that he can alter the configuration of the hurricane straps or pour the footers differently from what is the common practice. And that statute, 489, there's two statutes involved here. 489-127, which says that it is illegal for an unlicensed person to engage in general contracting in this state. It is also illegal for an unlicensed person to use the license of anybody else. That's what 489-127 says. And it's a crime. So there was a crime involved.
Both sides? It's illegal to lease your license to somebody as well, right? So you got it on both sides.
Yes, sir.
Okay.
It is.
Is it a crime to tell someone, if you give me this money, I'll give it to someone else and then keep it?
It would be fraud if you had a different intent at the time that you told them that. But if you later change your mind, it's not fraud.
So then this case really sort of resolves itself on the question of whether there's consideration for the undertaking to pay the money out.
That's one issue, but I don't think that's what resolves it. I think.
So your position is that your client could not legally have agreed to pay the money.
Correct. It would still be thwarting the purpose of the statute, and BOATWRIGHT would still be gaining the monies that he illegally.
Your client had no right to that money, did he?
Yes, he did.
Where does the right to the money come from? I asked you that question.
His undertaking of all of the contractual liabilities to take over that job.
It never says in that he does agree to supervise and to be responsible for any deficiencies in the work, but it never says, and that in return he'll get, at the time they ended the agreement, there was $600,000 outstanding, never said how much money he'd get paid for.
That's true.
In fact, the reason why your client entered into that agreement was because of the regulatory agency's threat to the approved license to begin. That's why the MRI doesn't have any undertaking to pay what we don't have to record is why the MRI agreed to pay anybody any money.
It's true that it's not in the record. Your Honors, I'd like to dispel some notions that counsel has raised in both his brief and in his arguments today. First of all, it repeatedly states that the public policy concerns of the Florida legislature aren't at stake in this case. And then it also says that because it says this because it repeatedly pronounces itself as being a qualified contractor, even though it's unlicensed. Second, it actually argues that the Florida legislature, and he argued this morning, that the Florida legislature really only meant that contracts between unlicensed contractors and individual consumers or unsophisticated owners are what the legislature meant.
Do you agree that the contract entered into by the unlicensed contractor has to be a construction contract to be illegal?
Under this statute?
Yes.
Yes, sir.
Okay. I mean, BOATWRIGHT could come to the state and rent an apartment, rent an office, buy equipment. All of those contracts would be enforceable, correct?
Sure.
So in order for this contract to be illegal and unenforceable, you have to determine that this is a contract relating to or arising out of construction?
Relating to or arising out of the practice of general contracting, yes, which is construction. General contracting as defined in the statute. The problem with BOATWRIGHT's position, and it simply assumes that Red Lobster is a sophisticated owner, but the problem with BOATWRIGHT's position on this is that in making these arguments, it's asking this court to establish a rule that private companies like BOATWRIGHT and Red Lobster, maybe even Enron, I say tongue-in-cheek, should be allowed to set themselves up to thwart or overrule the intent of the legislature. BOATWRIGHT is an unlicensed contractor, but he says he's qualified, so therefore it's okay, and he doesn't have to comply with our licensing statutes. Red Lobster is Red Lobster, therefore the division of it in charge of doing construction must be sophisticated, and therefore they have the right to enter into a contract with an unlicensed contractor. That's what the argument that's the result of the argument that they make. But we can't allow that in this state. The statutory scheme is that only licensed contractors are qualified to engage in general contracting in this state. And there was a lot of question about, the qualifying agent. There was never, the pleadings, this is a judgment on the pleadings, so all we're going on is the complaint here as the record. But the pleadings don't establish any kind of an agreement between BOATWRIGHT and Mr. TARR for him to act as a qualifying agent. What the pleading establishes is that the only agreement between them was that he was going to pull the permits for $2,500, and that's basically an agreement for them to rent his license, and that's illegal. Your Honor, am I over my time?
Yes, you are.
Well, all right. The other fallacy in their position is that Mr. BOATWRIGHT or BOATWRIGHT Construction was not in peri delicto with the appellee and didn't understand. I mean, that's all over their argument. But if we allow businesses to come down to Florida and make that kind of statement, I didn't know, I didn't understand, then we're subjecting ourselves to all kinds of things, because people are presumed to know the law of this state. They're presumed to come down here and understand that they're supposed to be licensed contractors. And if we make an exception for him because he says he didn't know, which I suggest is not very credible if you read all the exhibits to the complaint, one of the things, as well as the allegations of the complaint, he had another person that he was doing this with all over the state.
So we can't view credibility on a order of judgment on the proof.
Yeah, and we'll
Typically-
I think counsel, at this point, we'll hear from,
Okay,
we'll hear from.
thank you.
Thank you. One issue with respect to this qualifying agent issue and whether or not the parties understood or intended for Mr. TARR to be a qualifying agent for BOATWRIGHT. There is a case that this court decided in 2003, Mevan versus Metric Constructors, Inc., where it was on summary judgment, and what the court said in that case is that there would need to be an evidentiary hearing as to whether or not the party met the requirements of being a qualifying agent. I looked at the statute, obviously, and I think there are a number of hoops that you have to jump through for purposes of the Florida statute on qualifying agents that probably were not jumped through in this situation. I think what the more relevant inquiry becomes by the court is whether or not the parties understood that that's what they were doing and that's what they intended to do. So clearly, Florida law contemplates that an unlicensed contractor, such as BOATWRIGHT, could come into the state and build a Red Lobster restaurant or do something else as long as they had an appropriate qualifying agent. In this situation, BOATWRIGHT understood that that's what it had. Now, that's the problem, obviously. I mean, we're sitting here, and the party that is gaining the windfall from this is saying, hey, didn't turn out I was a qualifying agent, sorry. You know, didn't mean to tell you that. We had this agreement that was entered into, the retroactive fix of the problem has got to be read. It was 3 documents together. It doesn't make any sense that this was a novation that didn't involve BOATWRIGHT at all. BOATWRIGHT, there's no dispute at all, and you must assume, I mean, it's factually correct, but you almost must assume for purposes of this inquiry, BOATWRIGHT did all of this work. Mr. TARR didn't do any of it.
If we were to find a third-party beneficiary contract existed, which your client was the beneficiary, would your client then, would we be enforcing a situation where your client, where the court would be ordering someone to pay your client for contracting work done illegally?
Your Honor, I don't believe so, because what happens in this situation is the effect of, and there are 3 different agreements that you've got to read together as one, as the court knows is authorized to do that. The effect of the 3 agreements together are that Mr. TARR is now a qualifying agent. He's a secondary qualifying agent. We've solved the problem under the statute, and so it wouldn't be illegal for BOATWRIGHT to actually be paid for the work that it did. You've got to
He
read.
still didn't supervise the first 98% of the work done. And he
Understood.
was already under the hook on day one by loaning his license, the liability. So the statute goes beyond just having someone liable who has a license. It also requires that that person be out there supervising. So that novation agreement didn't put him on the hook for responsibility any more than he already was. They still didn't supervise the first 98% of the work.
That's true, Your Honor. I mean, the allegations here are that this was, and I understand what the purpose of the statute is. It's to keep from having unqualified contractors do the work. The court clearly can look at this situation and decide that BOATWRIGHT was a qualified contractor that would, had it had an appropriate secondary qualifying agent, it'd be fine. I mean, it was dealing with a sophisticated party that did understand the problem. I mean, to its credit, GMRI didn't just say, hey, sorry, we're keeping your money, don't finish the job. They wanted the job finished. They understood there was a problem, and they wanted to fix it. That's what the parties did. And then GMRI, that wasn't good enough. I agree that the guarantee and the acknowledgement and affirmation agreement themselves don't deal with the issue of payment. What they do is they say, hey, TARR thought he was a qualifying agent. That's what he intended to be. What we're intending to do is put this back where it should have been. Yeah, we can't make it perfect at this point because 98% of the work's done, but we're dealing with the contractor that we already know, that we're satisfied with the work that it has done. And all we want to make sure of, Mr. TARR, is that you're going to pay this money that we pay to you over to BOATWRIGHT. There's no other purpose for this May 25th letter from Mr. TARR. That was required. It was written to Ann Pinson at Darden Restaurants by Mr. TARR saying, if you pay me and I get a hold harmless, I'll pay the money over to BOATWRIGHT. It was copied to BOATWRIGHT. BOATWRIGHT was clearly intended to benefit from that, and BOATWRIGHT guaranteed TARR's performance under the Acknowledgement and Affirmation Agreement. So, call it whatever you want, but if you look at what was intended here and who's getting away with what, I mean, I don't believe there's any evidence in the record that BOATWRIGHT this was some sort of subterfuge by BOATWRIGHT to try to, it entered into a $1,400,000 contract. It paid a guy $2,500 to pull a permit for it. It would be crazy for BOATWRIGHT to enter into that kind of contract if it had any idea that it wouldn't be able to get paid for its work. Doesn't make any sense. And it would be just an egregious result.
Counsel, you've exhausted your time.
Thank you, Your Honor.
All right, then we're done for the day.